So, Lone Rider here, and I'm going to talk about the importance of the Open Public Record Act request. And, um, well, here we go. Um, you may have missed the news article on the front page of the New Jersey Star Ledger newspaper. This was on September 1st, 2016, and I think it's still relevant because, the Open Public Record Act is going to be relevant as long as the government does things that maybe they don't want us to know about, right? Um, the article was sort of hidden off in the corner, and I think that, I don't know, maybe people missed it or, didn't realize the importance of it because normally the lead article is in a certain position on the front page. But anyway, the title was, quote, "Ruling Tightens Access to Records," unquote. And the article was about an appeals court ruling in a case where a reporter sought government records via the Open Public Record Act request. The court ruled that the government could not only refuse to turn over the records, it could actually refuse to acknowledge whether or not they existed. And in this particular case, I think the court ruling was well intentioned. The reporter was trying to get information about a guy who'd been involved in a police investigation but never charged. And so the court probably saw it as, they're protecting his privacy, so he doesn't get unfairly tarred as a criminal. And I understand that. Nobody wants to have reporters, misreporting something and then making you out to look like you're something you're not. So obviously, yes, focusing on protecting the privacy of a person who was involved in a police investigation but never charged, that's important. But what's also important is not enabling the government to hide what it's doing any more than it already does. And the risk of this is that saying that the government can not only refuse to turn over the records, which they can already do under several existing exceptions to the Open Public Record Act law, but establishing that they can refuse to acknowledge whether or not they exist, that's very different. All right, that's very different. Had this ruling been in place when I started looking into the history behind the Union County ban on mountain biking, for example, I don't know if we would even have figured out all the things we figured out. Ultimately, the effort for mountain bike access failed because the government wasn't proceeding in good faith, but the point is, at least we were able to figure out the history behind the ban, which nobody ever knew before in 20 years because it was all done behind closed doors. However, if they had been allowed to say nothing, the way it stood, if they turn over the records, they have them. If they're not going to turn them over and they have them, they have to tell you and cite a particular exception. So if they don't say anything, then the record doesn't exist. This exception created potentially by this court ruling would allow them a third way, would allow them to just not say anything, and then you don't know whether the records exist or not, which would render the Open Public Record Act request useless for getting stuff that the government doesn't necessarily want to be above board about. And since there's a lot of things the government on various levels doesn't want to be above board about, the Open Public Record Act request, which is essentially the state or local version of the Freedom of Information Act, at least in concept, is important, right? And the response was called the Glomar Response. This was a reference to the Glomar Explorer, a ship that the U.S. secretly used during the Cold War to raise a sunken Soviet submarine. And the idea was that even acknowledging that it existed would be a risk to national security. So they could say nothing. It wasn't just like, okay, we're not going to tell you the details. We're not even going to tell you whether it exists. And that's, what? When you're talking about national security and nuclear submarines and stuff like that, the government has a duty and a responsibility to safeguard its secrets, right? However, when you're talking about the Open Public Record Act request, you're talking about local issues, right? You're talking about at the town or the county or the city or the state level. None of these things are things which really would affect national security one way or the other. It's an inappropriate use of this concept. And I'm not a lawyer, I don't play one on TV, but I'm looking at this as a layman. And I see a huge problem here. I mean, not only are they essentially comparing apples to oranges, and applying something that might fit in a case where there's an overriding national security implication, but certainly doesn't fit when you're talking about, hey, I want to know why I can't ride my bike in the park, or any other local government issue, right? It's that, generally the people filing these Open Record Act requests don't want access to secret agent or submarine records. They just want information about what their local government is doing or county government is doing. And this was especially true in my case with trying to get the origin of the mountain bike ban in Watchung Reservation in Union County, New Jersey. Because everything was done behind the scenes without citizen input or review, nobody knew what, according to the county, they did. In fact, nobody knew that, as the county later stated in an Open Record Act request, quote, the freeholders didn't act to exclude mountain biking, unquote. And then it was unelected representatives, or unelected employees rather, in a back room, rather than elected representatives who made the ban up out of whole cloth. And then decided to repurpose an old ordinance about roads, sidewalks, paths, and not blocking cars, and repeatedly misstate that it referred to trails, when of course it didn't, and yada yada, and all that's history. We know that now. We never knew that before. Until I started filing Open Record Act requests, people were under the impression that in 1995, somebody passed a law to ban mountain biking, or an ordinance to ban mountain biking. Turns out they never did. The ban was created in 1995 by a handful of the unelected in a backroom meeting, and the ordinance they say authorized it was from 1983 and was never explicitly linked in writing to that ban until 2014, when people like myself started asking questions. A lot of fishiness here. And we would never have been able to get to the bottom of that without the Open Public Record Act request. And, to this day, the county policy is murky. I mean, 20 years on, they repeatedly assured mountain bikers for 3 years they were working towards opening the park to mountain biking. And then, of course, ultimately that fell by the wayside. But if you look at the level of opacity of, the county government, just in this one instance, the OPRA request is essential. The Open Public Record Act request is very important because the government often doesn't operate in a clear and transparent manner. And this may not necessarily be because they have something to hide, although in this case I think we can all agree that it is. It may just be they don't feel the need to tell everybody what they're doing. Or that's just how they operate, Or in some cases like this, it may be because, their policy, isn't above board and it's not a good policy and it's not, properly arrived at. But currently the government is inaccessible enough. We don't need to make it easier for them to hide things from us. And a lawyer in this newspaper article is quoted as saying that, quote, requesters and their attorneys are going to have one arm tied behind their backs, unquote. And the concern is basically that this will be abused, allowing governments from state and county and local municipalities to start refusing everything. And like I said, already there are exceptions to the OPRA process that already exist, usually for personal privacy or, deliberative matters. I've already seen how that can be abused. I mean, in the one of the final Open Public Record Act requests I filed regarding the mountain bike thing, they said, well, this is deliberative, even though I was asking about something that, according to the government's earlier statements, they claimed had already been decided years ago. And then it was like, when I asked them to explain why something like that would be still deliberative and covered by a deliberative exception, they responded by saying, literally, deliberative means it's part of the deliberative process. I was like, what? Ultimately, I had to sue them to get access to that information. And it turned out there's a good reason they were trying to hide it. It related to warnings that were posted saying if you ride your bike in the park, it will be confiscated. And part of that email exchange showed them government people talking amongst themselves. And it showed in particular somebody from the Union County Park Police or Union County Police Department talking to the people from the Union County Parks Department and warning them that the threat to confiscate the bike simply because it's ridden in the park is not a legally authorized threat, that we cannot do that and you shouldn't put it on the signs. Well, of course, they didn't put that on the signs, but they ultimately did put it on flyers that were disseminated by the hundreds and perhaps thousands throughout the park system. So, essentially they made an illegal threat to confiscate people's property. A threat they knew was illegal because they'd been told it by other government people, and they don't put that on there. They did anyway. No wonder I had to sue them to get access to this information. So essentially, yeah, they already abuse existing exceptions. So do you want to give them more exceptions, right? Do you want to make it easier for them to keep things from the public view? And this new technique, which has never been applied to state level requests before, raises a lot of real concerns, especially for those of us who have seen how some local and county government decisions are made. I mean, the risk is one of a, to borrow a phrase from history, Iron Curtain, descending on the government and hiding government processes from the citizens who were then forced to live with the results. And it's ironic that the process used to deny the OPRA request in the news article was named after an issue that affects national security, the Glomar Response. Because there's nothing that endangers the nation, I think, more than the government, from the federal to the most local level, being even more unaccountable than they are now, right? I don't think there's anything more dangerous than allowing people that are supposed to represent us to act without accountability in the shadows with no mechanism of holding them accountable, let alone determining what it is they're actually doing. Right? I think the best defense against bad government policy or outright misgovernment and corruption is for people to know what it is the government is doing. And I think that's something all of us could agree on, whatever side of the political spectrum we're on. At least I'd hope so.